Good morning. Happy Wednesday, everybody. It's Wednesday, right? Yeah. Okay. Good to see you guys. Hopefully, maybe you saw that I had posted a little worksheet with some conveyances on them. I think it's got 6 or something like that conveyances, and it touches on a lot of the things that are on my little list of ways in which I can test you on conveyances. So on Monday, we will have a look at that, but please spend the time between now and then doing those and doing other conveyances if that's what you want to work on. That will be our task on Monday. Today, we've got the Schwartzball case finishing it up, and then I've got one other bit of content to go through with regard to concurrent estates, and then we're done. Then we've covered what we're going to cover in this course. So we are there. So let's get going. So on Monday, I think Ryan and Jasky and Austin were helping us work through the Schwartzball case. And Austin, without going fully into the details, if you could just remind us briefly sort of what was going on, just a quick version. We're not gonna go through the whole thing, just to sort of get us back on the same page.
Sure, yeah. So you have the Schwartzballs, who are husband and wife, and the husband wanted to lease the property to Samson, but you kind of ran into the two problems of how the wife did not want to lease the property, and kind of at the same time she got injured, which kind of hindered her right to enjoy the property. So she was trying to stop the lease.
Okay. And her theory was that the lease sort of injured her interests. How?
It almost kind of seemed like a constructive ouster type of situation, because even though she technically had the right of full enjoyment, she wasn't able to get any benefit because she was bedridden, and you had this lessee who had come in and pretty much just had exclusive rights to the property.
Yeah. So for the rest of the discussion, let's leave out the bedridden part of this. It adds to sort of why the case unfolds the way it does, but it's really not legally relevant that she was physically unable to enjoy the property. What I think is relevant, however, is that it appears that the property has been leased to Samson. And if it has been leased to Samson, so take it out of the concurrent estates context, Austin. If I am a landlord and I rent property to you, if I lease property to you, what have I given up? What do I lose as the landlord?
The present possession stick.
Exactly, the present possession. And you actually have, and I think, this is not like 100% the case, but the tenant actually has a right to exclude the landlord from the property, generally speaking, right? There might be some exceptions written into leases that allow the landlord to come on in certain circumstances. But as a general matter, a lease transfers possession and the right to exclude to the tenant. And so if this property has been fully leased to Samson, then what has Samson gained vis-a-vis Mrs. Schwartzball?
Well, I would think that he gets the full rights that Mr. Schwartzball had in joint tenancy, right?
But if it's a full lease, if it's a lease of everything, including her interests, so you're skipping ahead to what it actually was.
Well, if it was a full lease, then it would be full right of enjoyment, full exclusion of the whole property.
Including of Mrs. Schwartzball.
Yes.
Yeah. And so this is what she thinks has happened, right? And so she sues and says, this is infringing upon my rights. And you can't do that, right? You can't infringe upon my rights. And the court talks about this in saying, um, it is a general rule that an act of one joint tenant without express or implied authority from or consent of his co-tenant cannot bind or prejudicially affect the rights of the latter. So that's on 377. And that sounds a lot like our waste doctrine in the sense that one concurrent estate holder cannot use their sticks in a way that injures another. And so she's saying that this lease that you're doing is injuring my rights, and therefore I can cancel the lease. Okay, so that's Mrs. Schwartzbaugh's perspective, but Sampson has a different perspective on this, Ryan. And Sampson says, no. You can't cancel this lease. You can't kick me off this property. What does Sampson say has actually unfolded here rather than what Mrs. Schwartzbaugh says?
He only has Mr. Schwartzbaugh's stick, so he only has what he has.
And what does that include?
The right to full enjoyment.
Right to full enjoyment.
And
what else?
To do what he wants. But
right to do what he wants. So Mr. Schwartzbaugh, if Mr. Schwartzbaugh wanted to put a boxing pavilion on this property, could Mr. Schwartzbaugh do that?
Yes, because he has the right to full enjoyment.
And could Mrs. Schwartzbaugh stop him from doing that?
No.
No. And so Sampson says, no, I have the rights that Mr. Schwartzbaugh had, and those include the right to full enjoyment, to put on the boxing pavilion, etc. And I don't have what does Sampson say he doesn't have? I don't have what?
The right to exclude Mrs. Schwartzbaugh?
The right to exclude you. Okay. I don't have the right to exclude Mrs. Schwartzbaugh. So what is Sampson paying for?
Mr. Schwartzbaugh's sticks.
Great. And so, Ryan, who prevails according to the court here? The interpretation of Sampson or the interpretation of Mrs. Schwartzbaugh with regard to what this lease is?
Sampson.
Sampson. And why?
Because the rules say that you can only give what you have. So Mr. Schwartzbaugh never had Mrs. Schwartzbaugh's sticks, so he could only give. So Ms. Schwartzbaugh never lost her rights.
Does it matter that Sampson knew that that was the case?
I mean, I think it helps him, but I don't think it actually matters, because it doesn't matter what you think you can give. It only matters what you actually give.
Okay, well, let's exist in an alternate universe for a second. Okay, where what happened with Mr. Schwartzbaugh trying to get Mrs. Schwartzbaugh to sign on to this, and she like abjectly refusing, right? And Sampson knowing about all that. Let's imagine a situation in which Sampson is unaware of that dispute, that internal dispute among the joint tenants. And Mr. Schwartzbaugh comes and says, I'd like to lease the property to you for $1,000 a month. Okay. What does Sampson probably think that he's getting in that alternate universe?
He would probably think that the wife was in on it as well, because they're married and probably making these decisions together. So it would make sense that he would expect that he was getting the full rights of the property, including hers.
He would have had an expectation that for that $1,000, he was paying for not just Mr. Schwartzbaugh's interest, but also Mrs. Schwartzbaugh's interest. What does he think, back to reality, what does he think he's paying for here in this case?
He says he only knows that he's taking Mr. Schwartzbaugh's interest.
So what do you think if it was $1,000 rent for everybody's interests? Do you think that what he's paying would be more or less than that, or the same?
Less, because he's not getting everybody's interest.
Great. So he's probably, if he is aware that he is paying for, that he is only getting Mr. Schwartzbaugh's interest, then presumably he is paying less than what he would be paying for the full right to exclude everyone, including Mrs. Schwartzbaugh, right? And so if he's paying rent here, he's only paying for the sticks that he has or that he is expecting to get. And so, Ryan, what I guess I'm asking for is if his expectation in the negotiation on the lease, particularly in the rental amount, was that he was paying for all, which it wasn't here, but if that was it, then, and he's paying the $1,000, then how would that change? How would that change things? Could she cancel the lease at that point? If he thought he was getting both of their sticks, both of their interests.
I mean, I wouldn't it be on him to cancel it, not her, Samson, to cancel it, because he's the one kind of getting the short end of the stick. Haha.
Good one. So how would why would he cancel it? Who would he sue? Let's say that's the situation, and he's got a problem with this. Who would his problem be with?
Mr. Schwartzball.
And what would he be asking for? Maybe to cancel the lease, but really, what would he want?
A different payment, to pay less because he's not.
Right, a rental amount that better reflects what the sticks he is actually getting. Okay, and so I do think this case turns on the fact that Samson is well aware that what he is paying for is not the full sticks of both Mr. and Mrs. Schwartzball. Rather, Samson is well aware that what he has agreed to pay, whatever he's paying for, the rental amount, whatever it is, he knows it's only for Mr. Schwartzball's interest. And he would have to pay more if it was going to be for her interest as well. Okay. And so let's go back to the alternate universe, if it wasn't that, right? If he didn't know and he thought he was paying for the full interests, right? Of both joint tenants. If that were the case, then either she, Mrs. Schwartzball, could successfully sue to cancel the lease because the lease would have violated her rights, right? If Mr. Schwartzball purported to lease her rights for her, which he cannot do, if that is what had happened, she probably could have canceled the lease. Alternatively, if a court wouldn't have allowed her to cancel the lease, because sometimes there might be like a reliance interest or some sort of good faith lessor, or good faith lessee, I guess, in this example, so kind of like a good faith purchaser. If Samson had no reason to know that what he was buying or what he was leasing, that Mr. Schwartzball didn't have the authority to lease, if Samson didn't know that, then he might be a good faith lessee, and so the lease might not be cancelable. But Ryan, what do you think she could get at that point?
Some of the rental money.
Some of the rental money, right? And so that answer is one of the things that kind of makes it interesting that they're married, because I like to imagine a situation in which she's suing her husband for a portion of the proceeds for their jointly held property. You know, it's just not good. Those of you who are married, it's just not good, right? Don't sue your spouse for owing each other money while if you want to continue the marriage. So that, you know, that's just some free marital advice here. So, but that's not what happened, right? What happened is Samson knew, and so Samson, as Ryan has said, was leasing only the portion of the interests that were Mr. Schwartzball's. And that's the outcome, right? She cannot cancel the lease because he could not lease out her stuff, and therefore did not lease out her stuff, and therefore Samson can move forward with the boxing pavilion. So Jaski, that leaves her in a tough spot. So she's lost. She can't cancel the lease. What should she do? What should she do next? If you were advising Mrs. Schwartzball and she really didn't want this boxing pavilion there, what would her next step be? Or what are some options, I guess? There's about 5 different things she could do, maybe less, but several.
I mean, she could ask to partition the land.
Okay, so there's one option. So what's the upside of that?
Well, it severs the joint tenancy, so she would. I mean, she would have her plot, and then the husband would have his, and um, so that's a upside to it.
So the upside is she at least for a portion of the property can save all the walnut trees.
Yeah.
Okay. But you mentioned that it severs the joint tenancy. So what are some of the downsides of the partition?
Um, let's see. It severs the joint tenancy, so it doesn't have the right of survivorship. I don't think.
So the right of survivorship goes away. So her chance of ever owning all of this walnut grove is walnut is gone, right? So she's lost that.
Mhm.
Okay. And what about, so you said she can protect all the walnut trees on a portion of the property, but what about the other portion of the property if it's a partition?
I couldn't hear you for that last bit. Say that again.
What about so you said she could protect all of the walnut trees on a portion of the property, but what about the walnut trees on the other portion?
Well, she doesn't have rights to it because it's
Yeah,
not.
they're gone, right? Those
Mhm.
those walnut trees are gone. So she could seek a partition. So there's one option. Got any other ideas for her?
She could ask for accounting, so a part of the money from the lease, so she could get monetary compensation.
Okay, so
for-
she could say, hey, I might not be able to keep this guy out, but at least I should be getting a portion of this money. Do you think that would be successful under the way that the court reads what's happened here?
I don't think so. Just because, like, if Mr. Schwartzbach only gave his rights and hers weren't impeded on, then I think under the reasoning that the court would be like, well, if you didn't give anything up, what are you owed?
Exactly. Okay, so I'm hoping everybody followed that. Though she could theoretically seek a portion of the rent that Sampson is paying currently to Mr. Schwartzbaugh, I think that the reasoning of this case suggests that she would not win that she would lose. Because, as Jasky has said, she didn't really give anything up here, right? She hasn't lost anything. She still has the right to full enjoyment. She still has her portion. She just happens to be, at least temporarily, for this portion of the property in a joint tenancy now with Sampson instead of with her husband. Okay, so she could theoretically do that, but I think she'd lose. So partition is an option that could work, but has upsides and downsides. This seeking an accounting, we might think it's a good idea because at least she can get paid for it. But I think Jasky's right. It's a loser, right? It's not going to succeed because of the way that the court evaluates what has happened here. So partition is on the list. Accounting action, which we'll talk about a little later, not on the list because it's not going to succeed. What else could she do?
She could try to gain part of the possession stick and exercise her right to enter, or at least try to if she wasn't injured.
And so she could use the property. Maybe she could. How could she use it that might stop the boxing pavilion?
Maybe she builds a like an encampment or an encroachment around the walnut trees, and then she, I don't know, calls it a walnut grove garden, something, makes it like an attraction. I don't know.
I like to imagine her strapping herself to the walnut trees and saying, you'll cut down these trees over my dead body, or something really dramatic. That's what I like to imagine. But your walnut tree attraction would be nice as well. The point is she could use the property, right? Now, what is the danger of that course of action?
if Samson really wants to cut down those walnut trees and will do it through her dead body, that's a danger.
Okay, yeah, that would be bad.
And let's see.
Ultimately, what are you asking her to do? You're asking her to use the property in what kind of way? In a way that prevents what from happening?
Like adverse possession almost,
Mm,
but he's not
maybe.
adversely possession.
A step before that, I think. Could end up being adverse possession, but there's a step before. You're asking her to use the property in a way that prevents who from doing what?
It prevents Samson from using it in the way he wants.
And can a co-tenant prevent another co-tenant from using the property in the way they want? Legally?
No, but at the same time, if you're a co-tenant and you use the property in a way that you want, like, and it's not the way that the other person wants, in a way that's already doing that.
Austin, what's the word for what she might be doing if she uses it in a way that prevents Samson from doing the boxing pavilion?
Would she be ousting him?
Could be ousting him, right? So we know from Spiller that he's going to actually have to attempt to use, and she's going to have to stop him from using. But if that's what happens, which I think Jaski's right, that is one option she has. If that happens, Austin, then what? What is she now on the hook for?
Getting in the way of his right to full enjoyment.
So that's what she's done. So what is that? What is the effect of that? What is the effect of an ouster?
I mean, it's getting in the way of the joint tenancy that's still there. I'm not sure exactly what you're looking for.
Yeah, so if one co-tenant ousts another co-tenant, you know, Jaski said that could start adverse possession, right? So we're sort of tiptoeing towards adverse possession, but even independent of adverse possession, Jaski, what is the effect of when one co-tenant ousts another co-tenant?
I mean, in a legal sense, it's almost moving towards severing the joint tenancy,
Maybe.
or at least
Acting as
though
there isn't a joint tenancy. That's true. Ryan, what do we got here? If one co-tenant ousts another co-tenant, what obligation does that put on the ousting co-tenant?
You would be exercising a right to exclude that you don't have.
Right. So you guys are all describing to me what happens. I know the Spiller people are out there and they're thinking they know the answer to this, right? The Spiller people ought to be screaming into their mute, you know, what the effect is. What is the effect of ouster?
Wait, she's got to pay him?
Yeah. What does she have to pay? She has to pay rent. Generally speaking, you do not pay rent between co-tenants, but if you oust a co-tenant, then you owe rent to that co-tenant. So if Jaski, she does what you're suggesting, which I think could save the walnut trees, she might be opening herself up to then owe Samson rent. And it's probably going to be rent in the amount that whatever Samson is paying, right? Samson is paying, let's say, $1,000 a month to have access to this property. She has denied him access to this property. So presumably she is going to have to compensate him for that. She has taken sticks that he has by ousting him. Okay? Is everybody following that? So she could use the property in a way that ousts Samson, but if she does, then she might be on the hook to pay Samson. So she can't cancel the lease, but she can kick Samson off so long as she pays him for it. Yeah, Austin.
Would that still be the case if she were operating like an actual walnut like business or something, and like making walnuts for sale, as opposed to just arbitrarily protecting the trees?
I don't think it makes any difference.
Okay.
I think what we need here is a demand, just like in Spiller, an explicit demand by Samson to use the property and an explicit refusal or denial by Mrs. Schwartzbaugh of Samson's ability to do so. Whether that denial is accompanied by her strapping herself to a tree or roping off the property or putting a gate around it with a lock or operating a walnut business, whatever that would be, it doesn't matter. The point is, if there is a demand and a refusal, then we've got ouster, and then she would owe the rent. Okay. Now, Jasky, what if she tries to use the property, and in the sort of direction we just went was she's successful, right? But what if she's not successful? What if she shows up and she's like, I'm here to start my Walnut amusement park, and I'd like to do so. And Samson is there, with the boxing pavilion construction company. And Samson says, get out of here, Mrs. Schwartzbaugh. What is the effect of that?
Well, then he's ousting her from full enjoyment of the property.
Mm-hmm.
So I would think that he'd have to pay her then.
Great. So you mentioned before that she could sue for an accounting of the rent that is currently being paid to Mr. Schwartzbaugh. And then you correctly identify that wouldn't work because she hasn't actually lost anything yet. But if she were to get herself ousted, okay, in this new sort of post-suit action, if she were to get herself ousted, then she would be due rent. Would he be paying Jasky? Let's say he's paying $1,000 to Mr. Schwartzbaugh. Would it come out of that $1,000, or would it be on top of that $1,000, what he owed her?
I think it would go above that because he already has all of Mr. Schwartzbaugh's rights or his sticks. And then if he's taking basically part of Mrs. Schwartzbaugh's sticks, then for that stick that he's gaining, that'd be more than what he's paying. So he would owe her on top of that.
I think that's exactly right. Right. So the $1,000 that I'm referring to is completely unrelated to what he would owe her. And in fact, he would owe her the fair market value of her interests, which might be an extra $1,000, right? Presumably her interests are valued the same as his interests, but it might be different, right? Mr. Schwartzbaugh might have given Samson a discount or something like that. The fair market value, fair rental value for her interests might be $2,000 or something like that. But it doesn't make any difference. The point is, it's going to be an amount on top of whatever he's paying to Mr. Schwartzbaugh, whatever Samson is paying to Mr. Schwartzbaugh. If Samson ousts her, then she is owed rent in the amount of the fair rental value of the interest that she has lost. Okay, that she has been ousted from. Okay. What else could she do? Ryan, any other ideas? So she could get herself ousted. She could oust. She could partition. What about something a little more cooperative?
I don't know if this is exactly what you're looking for, but in the notes it talks about repairs and improvements. So he could be responsible for repairs and improvements to the land because she suffered a loss in a way.
Okay, maybe that is we're going to get to repairs and improvements in a second, but I'm looking for a resolution for her, or an action that she could take that would, essentially stop that would essentially recognize her rights here, right? She can't cancel the lease, but legally, but what might she be able to do? Austin, you got any ideas?
I mean, one of the more extreme ones, like we have been talking about, would be like partition and sale.
Okay.
Because then, I mean, that kind of goes against what she's trying to protect anyway, but she could at least like force it to be sold to somebody else, maybe, and then she could get proceeds from that, but then she would lose the land entirely. But I guess on a less extreme note, she could just figure out some way to negotiate with Samson. I don't know exactly what that might entail, but just something that he could promise to do, just to make her happier with the lease.
Good. So the first thing you mentioned, I think, is just a different version of partition, which we've already got on the table here. But the second thing, where she could approach Samson and say, all right, look, I can't cancel the lease, but I can make your life miserable here with boxing protests every time that you want to have a boxing match or whatever. Let's come to some sort of agreement that, because, I can do that because I have right to full enjoyment. And if you're going to deny me my right to full enjoyment, then you're going to have to pay me. So let's come to some sort of agreement here. There's really an infinite number of ways in which they could agree on how to work this out. It's possible that it's irreconcilable and that we're going to have to go to partition, but it's also possible that they can come to some sort of negotiated agreement that everybody is okay with moving forward. She could theoretically even find an investor or find a friend who loves walnut trees as much as she does, and go to sort of sell the whole property, right? Buy the property with this new person, get her husband out of the way and Samson out of the way, and have a separate ownership group come in and buy this property. So there's really a lot of ways in which she can move forward. What she cannot do, and what I want y'all to make sure you have straight here, is cancel the lease. And the reason she can't is because her interests were not affected by the lease. Even though it seems like they were, the court is reading this in a way that suggests that they are not. Okay? So questions on Schwartzball. It's a very strict application of the rule that you, even as a co-tenant, can only lease out, impact, encumber the rights that you have. You cannot prejudicially impact the other co-tenants' rights. Okay? And so we see the effect of that in this particular case. Yeah, JC.
Could Ms. Schwartzball on, like, I guess our prior, what we were just talking about, also trying to get an injunction for waste for Samson trying to deteriorate the value of the land?
Maybe. It's possible, though. So it's a little more complicated in this context than it would be in a life estate remainder context, because though she does have her rights to this property, if she were to stop Samson or her husband, for example, from cutting down the trees, that would be a form of ouster on her part. And so the waste doctrine doesn't apply exactly the same way in the concurrent estate, because concurrent estate holders do both have present interests and do both have the right to use and the right to full enjoyment. And so you could get that, but you might have to compensate Mr. or Sampson
Mhm.
for doing so, because it could be seen as a form of ouster.
Yeah, that makes sense. Thank you.
Others on this case? Yeah, Jack?
Under note 3, the taxes, mortgage payments, etc. Would that just be under like the agreements that we just talked about where, hey, yeah, you can use the tree area, but how about you help me out with the mortgage payments each month or something like that?
That could be something. We're going to talk in more detail just now about that section, the accounting for benefits section.
Yes, sir.
So if y'all have questions on that, which you might, hold those for a second. But to Jack's point, those are the kinds of things that would be included in a general agreement among concurrent estate holders. I'll live here and I'll pay the taxes, and I'll therefore have the right to exclude you, right? I'm going to say 99%, but that's not mathematically accurate. Like, I'm just doing that figuratively. Most concurrent estates have some sort of formal or informal agreement among the concurrent estate holders that solve these kinds of problems. Okay. And so obviously we're encountering cases in which that's not true. But most of the time, all of these little things are bargaining chips that are part of negotiated agreements among concurrent estate holders. Okay, so if there's no questions, let's move on to sort of specifically covering those notes, the notes that are on 380 through 382. And I want to just walk us through 4 distinct rules, I guess, to apply in these concurrent estate contexts with regard to costs that might come up or benefits that are accrued for concurrent estate holders. So I'm going to do that. All right. And so we're going to start with just a basic to A, B, and C conveyance where A, B, and C are tenants in common with 1/3 each. And we'll begin with just some basic facts, which are B and C live out of town. A finds a tenant for the property. So they're going to rent this property out, but A is doing all the work. Okay. And the tenant pays $3,000 a month rent. And they do this directly to A because A is the only person that the tenant has ever dealt with. A, seems to be the owner of this property from the tenant's perspective. And so let's leave out all of the sort of mess that existed in the Schwartzbaugh case and say that A has the permission to do this, right? That all B and C want is the rental income. They don't care about being on the property. They want A to go out and find a tenant, and A does, and A gets the $3,000 check every single month. Okay. Or alternatively, let's imagine a slightly different situation in which B and C are still out of town, but instead of finding a tenant, A knows that there's oil underneath the property and sort of grants a license to an oil company to come onto the property and take the oil. And they do this and they pay the fee directly to A. So you see in both circumstances, A is getting the entirety of the payouts, right? One of these, the rent is rent, and the other is called a profit from the land, okay? And so B and C might be thinking, hey, what's going on here? Hopefully there's some sort of agreement where A will pay the proportion that is due to B and C out, right? Maybe there's an agreement that says A gets some sort of percentage fee, for being the manager, the one that's doing this work. Okay. But let's say A doesn't do this and A pockets all the cash. what do B and C do in that situation? So what they do is they bring what's called an accounting action. And we talked about this a little bit with Jasky about trying to get Mrs. Schwartzwald trying to get the rent. We talked about also why that would not be successful in that circumstance. But here, I do think it would be successful. Accounting action is an action brought by a co-tenant to receive their appropriate proceeds from rent or from profits from the land. Okay. An action brought by co-tenants to receive their appropriate proportional proceeds from rent or profits from the land. So if there is money being made, not from like, just let's make a slight different situation. Let's say A is running a graphic design business while living on this property, and the graphic design business makes $30,000 a month or something like that. Well, B and C are not entitled to, a third of that $30,000 simply because A is living on the property and doing something. Rather, this accounting action is meant to account for value that is directly tied to the ownership of the land, like rent, or like profits from the land, like from oil drilling or something along those lines. Okay, so an accounting action allows for B and C to sue to get their share of the $3,000 each month. So $1,000 for B and $1,000 for C. Maybe some courts would give a slightly larger percentage in order to cover the management costs, the management fees, or something along those lines. And so that is the way accounting works. Charles is asking in the chat, what about farming? So farming is a little bit of a special case in which we have to separate out the profits from the land, which would include the, like if it's corn or wheat or something like that, the profits from the sale of corn or wheat from the labor costs. So in this instance, in a farming situation, the profits would have to be calculated minus the labor. So obviously, if A is doing the farming, let's just imagine that A is doing it all themselves. If that's what's happening, then we would calculate out whatever that labor would cost as a, as an expense in the farming process, and then whatever's left would be the profit that would then have to be split in thirds. Charles, is that making sense? So it starts to become good. So it starts to become a little more complicated when there's a combination of profit from the land and profit from the laborer. Okay, so if A is not only just, so like in the oil example, A has just, they're not doing anything. They've just found somebody and they're leasing out or licensing out use of their property. The farming example seems to have A doing a little more labor. And so we might have to disentangle that, and it becomes complicated. So I want y'all to hear me say that, but not worry too much about it. Okay, that's what you would have to do if there was an entanglement of the labor. What portion of the profits is from the labor. In the graphic design, all of the profits are from A's labor. In the oil, none of the profits are from A's labor. In the farming, it's kind of in between, right? Some of it is from the labor, some of it is actually from the soil. And so it's kind of a mixed area. Other questions on accounting? Yep, Jack?
So say his graphic design business was on a plot of land that was like 5 acres and it took up 2 acres and there were, for example, 5 co-tenants. Could the co-tenants who didn't have the business kind of seek some form of payment for the loss of interest, albeit not that much, if that makes sense?
Where is their loss of interest?
So I assume unless otherwise agreed, that there's 5 co-tenants for a 5-acre plot of land. It would they'd each have 1 acre, and say set saying, hey, you're taking more than your interest, and then seeking to maybe make up for that with payments or something.
Can somebody set him straight? Is that how co-tenancy works? That each of them has 1 acre? Yeah, Austin?
They each have the full right of enjoyment to all 5 acres, so they can't really do anything about that.
Yeah, the graphic designer hasn't done anything wrong. The graphic designer can use all 5 acres and not have to compensate unless what happens? Jack, what do you think?
Someone attempts to maybe go on the premises of his business, and he says, well, you can't be here. Then he would have to start paying them because they'd be ousted at that point.
Exactly. Exactly. So until there's been ouster, then I don't think that what you're asking for would be necessary or would be appropriate.
Thank you.
Mhm. Others on accounting? Okay. So these are good things that come from the property. What about costs that come from the property? So we've got the same situation, except instead of the rent or profits from the land, we have payments in the form of taxes or mortgage payments. Okay. So rather than an accounting action, and let's just say A is exclusively paying this. Okay. So A is exclusively paying it. So rather than an accounting action, what we have is during co-tenancy, what we'll call an overpaying co-tenant can sue for a right to contribution for the portion of costs like taxes and mortgage payments that they are overpaying, right? So in most jurisdictions, A can sue B and C to obtain the portion of the taxes that B and C should have paid. Okay. And even though this might be the case, it might be a case where A is living on the property and B and C are not living on the property. The reason that even when that's the situation, that in most jurisdictions, A can still recover is because what you are avoiding by paying the taxes or by paying the mortgage is foreclosure. And foreclosure, which is where a creditor comes on and takes the property in order to satisfy a debt, foreclosure will cancel everyone's interests. So if this property goes into foreclosure for failure to pay taxes or for failure to pay mortgage payments or whatever, then B and C are going to lose their interests also. And so therefore they are on the hook as well for the taxes and mortgage payments that A has overpaid. Okay. But you can see in the text there is a small exception in some jurisdictions. Okay. In minority of jurisdictions, there's an exception that says a co-tenant in exclusive possession may be precluded from obtaining a right of contribution for overpayment of mortgage payments, not tax, but mortgage payments. Okay. This often has something to do with the way in which the mortgage is contracted. So mortgages are not just property interest, there's also a contract involved. And it is often the case that in that kind of example, A might be the only one listed on the mortgage. Okay, that A is the only one that's actually getting the day-to-day use benefit. I will note, as a matter of logic and principle, I think that this exception doesn't make any sense, but I want you to be aware of it. Okay, that in some jurisdictions, a co-tenant in exclusive possession might not be able to get a right of contribution for mortgage payments. Okay, that will not be the rule in our course. because I don't think it makes sense, but I want you to be aware of it. So note with both accounting and right of contribution, this is kind of to Jack's question from before we started here. These are all things that can be agreed upon independent of these rules that I'm laying out for you, right? So if A, B, and C come together and say, listen, A, you're going to live in this property and we're not going to ever come on this property. And in order to account for, to sort of make that worth our while, you're going to pay all the taxes, and that's what they agree to, then that's what governs, right? The agreement that they come to is what governs. What I'm giving you with this accounting action and right of contribution, these general rules are default rules that apply only if the parties haven't agreed otherwise. Okay? Only if the parties haven't agreed otherwise. Okay? Questions on the right of contribution? Okay. Let's keep moving. Now we're going to have a repair. Okay, so A, B, and C are fee simple holders, 1/3 each, tenants in common. The roof breaks and A spends $3,000 fixing it. Can A sue to force B and C to pay $1,000 each for this necessary repair? Let's see. A is yes, A should be able to get reimbursed. B is no, should not be. Note that I asked the question should be, as opposed to if you've done the reading, you should know the answer, what it is. I always love when people put the C. Just contrarians. Refuse to be put in a box. I like that. I suppose C always is, it depends. So A says, yeah, A can get them to pay. B says, nope, A cannot. So most of you guys say A should be able to recover. Okay, the overpayment for repairs. And so the answer is, not really. Okay, not really. So necessary repairs, A cannot get reimbursement for overpayment for repairs during co-tenancy. I should add that in. So long as the property is held in co-tenancy, A is out of luck here. They fixed the roof. They spent a full $3,000 out of their own pocket to fix it. They may not even be the one living there, right? It may be leased out, or maybe no one lives there, or whatever. It doesn't really matter. The point is, if A is the repairing co-tenant, they have no right to contribution, no right for reimbursement for overpaying for repair during co-tenancy. However, if there is a partition, then A is given credit for their overpayment when the partition occurs. Okay, so this is called credit upon partition. So no right of contribution, but credit upon partition for A in this example. Again, keeping in mind that if the parties have an agreement, then that governs. This is only the way in which we'll solve this problem if the parties, A, don't have an agreement up front, and B, can't come to some sort of negotiated settlement after the repair has come up. Okay, so again, a default rule that only applies if the parties don't agree on some other solution here. Okay, and so the question might be, how does that work? So it works like this. Let's say that during the co-tenancy, A has no right to anything, but they keep their receipt and they say, you know what, I've paid for this roof. I've paid for this roof and it had to happen. The water was coming in. It was terrible. I had to pay for the roof. Okay. Okay. So that is what has happened. They've got their receipt. Then somebody, it doesn't matter who it is, could be A, could be B, could be C, sues for partition. And maybe they're going to, let's just for this purpose say that it's going to be a partition by sale. So here's how it works. The sale is for $77,000. Before that $77,000 is split the three ways as it normally would be, A is given credit. A is given their reimbursement for the amount that they overpaid for the repair. The remaining $75,000 will then be split three ways. Okay? So A will end up with 27 and B and C will end up with 25 each in this circumstance. I don't want y'all to worry too much about the math. I want y'all to worry about the concept of no reimbursement during co-tenancy, but credit upon partition. Okay. Yale, I saw your hand up for a second. Are you?
Yeah, this might be a dumb question, but if A sells, sells their portion, does the credit upon partition also go forward to if they sell to X?
Good question. I think that the answer would have to be yes, because whatever interest that A had, which include this potential credit upon partition, would go also to whoever they give their sticks to. So imagine, let's say it's not a sale to X, but let's say A dies and leaves it to X. I think that the same thing would be true. Yeah, Tommy.
Would A only have to give 1,000 of the dollars?
I didn't hear the first part of what you said.
So in that hypo, when A sells their sticks,
Mhm.
would they only have to pay their portion of the overpayment? So they would just pay 1,000?
When they sell, why are they paying anything? If they're selling it, aren't they getting money?
Oh, I'm sorry. That would just 1,000 come out of the proceeds from that sale.
Let's back up. What sale are we talking? First of all, are you talking about in Yale's example where A
Yes,
sells their share in the tenancy in common?
Yes.
Okay. So this is before a partition sale happens,
Correct.
right? So we're back up in this universe. And I had 3,000, but I saw that I screwed that up. So let's say it's 2,000. So A sells to X for whatever, right?
Right.
Okay. So now walk me through what you're asking.
So in Yale's hypo, you were saying that during that sale that they would have to pay out for the necessary repairs out of the proceeds, correct?
No, not until a partition occurs. So as long as there's co-tenancy, it doesn't matter that A might sell to X or B might sell to Y or C might sell to Z. As long as it's co-tenancy, then nothing happens with this. Okay.
Okay.
Does that make sense? So it's only upon the partition sale that A or X or whomever can be reimbursed.
Gotcha.
Austin Henderson.
Why, when the partition sale happens, does A get the full 2,000 rather than it be split evenly with regard to his purchase?
Yeah, so that so I really maybe it should be 3,000. Maybe that's why I had 3,000 in the beginning. So yeah, this is why I tell y'all not to worry about the math. So does that make better sense, Austin? If it's if they spent 3,000 and now it's, yeah, I think this was better. Does that make better sense?
So if it was 3,000, they would get 2,000 back.
Correct. And if it's 2,000, they would get 2/3 of 2,000 back, whatever that is.
But my question is, so that's them. Is it because it's an overpayment
Correct. They have-
rather than a fair amount of, rather than them paying like a split, essentially?
Right. So technically for a necessary repair, and I want everybody to hear this, there's a whole doctrine of law about when a repair is necessary and whether the amount that is spent on it is reasonable, that is outside the scope of this conversation. So I'm just going to assert that it's a necessary repair and A spent a reasonable amount fixing it. Okay, so that's that. When there is a necessary repair, when A takes on the full cost of that, they essentially have a receipt that says, when partition happens with this property, I'm going to get it's like I have an IOU. I have an IOU from B for for 1,000 because they should have paid 1/3 of this repair, and I have an IOU from C for 1,000 because they should have paid a third of this repair. Okay, and so that is what sort of comes to that gets called upon when the partition occurs, and so that's where that $2,000 is coming from. Does that make sense?
Yes, that makes sense. That's what I was
So
thinking.
I did have it right in the first place that it's 3,000. So I try to make a change on the fly and I end up screwing myself up. Yale, yeah.
So I have another question. So if they're doing a partition, if they just partition the land and not the sale in kind, would they get extra land?
Yeah. So that's this one. It is a partition in kind instead. Either A will be given a slightly larger than 1/3 portion of the land, or the court will order payment of that 1,000 from each of B and C in the form of OLT. Okay, so it might be that they get 1/3 plus, whatever portion to reflect their overpayment. But I think it's actually in this instance more likely that the court will split it in kind in thirds and order payment of the 1,000 from B and 1,000 from C. So if it's a partition in kind, it's slightly more complicated, but ends up with the same basic principle. Question on repairs. Okay. What about improvements? A installs a swimming pool for $3,000. Can A sue to force B and C to pay their share of the cost of the installation of the swimming pool? Let's see. Y'all think A should be is yes, A should not be able to is B. So there's something different about a repair and an improvement, right? Repair implies necessity, improvement implies discretionary choice. There is, like I was alluding to before, a lot of gray space between when something is a repair versus an improvement, right? When is it necessary versus when, like if the roof is old but not broken and we put in a nice new roof, then is that an improvement or is that a necessary repair? Okay, so those are the kinds of questions that are more difficult in this space, that are beyond what we're going to be able to cover. And But I want y'all to just sort of be aware. So you can see most of you guys say no, they should not be able to recover for the overpayment for an improvement. And that is, again, kind of right. Okay, kind of correct. So improvements are slightly different. Improvements are slightly different, but similar in that there is no right of contribution or reimbursement or anything during co-tenancy. So just like with repairs, A cannot come and say, hey, I put in this pool, isn't it great? You know, which, by the way, B and C can enjoy, right? They have right to full enjoyment. So the pool is there and B can come jump in. But A cannot get B or C to pay them for the cost of the swimming pool during co-tenancy. However, and again, unless they've come to some sort of agreement. If they've come to some sort of agreement, then we're out of this whole conversation. But if they haven't, then no right of contribution during co-tenancy, but the improving co-tenant receives, instead of credit upon partition, receives value upon partition, the value of the improvement. So it's actually not relevant in this instance what the cost of the swimming pool was. Okay, the cost matters when it's a repair because you get credit for the costs. But with an improvement, it is a little bit different. You get value of the improvement. So what you need to know is not that it costs $3,000 to put in the pool. What you need to know is the impact that the pool had on the overall value of the property. So here, let's say that the value of the property before the pool was 75, the value after the pool was 82, and so the value of the improvement was 7,000. Note that that means A made a good choice here, right? They spent $3,000 out of pocket to add $7,000 to the value of the property. Okay. And the way that value upon partition works is that A gets the value off the top before whatever is left over is split according to the interests. Okay, so in this instance, let's say it partition sales for 82 because that's the value with the pool. A will get the 7,000, that's the value. They get the full of it because they took on the full of the improvement cost. So they get the full value of the improvement. And then the remainder gets split 3 ways. So A ends up with 32, B and C with 25 apiece. Value upon improvement. Note that if this number was 1,000, right, the value of the improvement was $1,000, that would then have been a bad investment for for A to have done, right? They spent 3,000 to get 1,000 in added value, but they would still get that, right? So it would be 26, 25, 25 in that example, okay? Now, you may be wondering what happens if the improvement devalues the property, okay? So let's say that the pool is really nasty and ugly and A has very bad taste and spends $3,000 on a pool that actually devalues the property by $5,000. When this happens, it's a little harder to articulate the way that it works, but I think it's pretty easy to see what the outcome ought to be in this example in particular. The outcome when you have a $70,000 sale for property that was valued at 75, but now because of the improvement is down to 70, is that it will be split this way. A takes the full loss. Just like in the previous example, A took the full gain, the upside risk. Here, A takes the full loss, the downside risk, and B and C shares are not affected. Okay, so the improving co-tenant takes an upside and downside risk when they improve unilaterally. Okay, they will get the full value of the improvement, but they will also share the full loss of. I mean, they will also take on the full value of a loss of value in improvement. Gosh, that was jumbled. Hopefully, y'all get the idea. Okay. Now, you guys might be wondering, well, how do you know that the only impact on the value change was the improvement, right? Maybe it wasn't just the pool. Maybe, you know, there was some sort of garbage dump that moved into the neighborhood that devalued the property. Okay, you're right. It's very, very difficult to prove these numbers. The value of the property before there was a pool, the value of the property after the pool, and the impact specifically of a pool on a property's value. I'm going to say that is a problem that you can deal with when you are a practicing lawyer or when you are worried about proof and evidence. Okay, I am just asserting that we are able to prove these values and prove that the improvement is what caused, in this example, the $5,000 drop, and in this example, the $7,000 gain. I acknowledge fully that proving that can be very, very difficult. And since it can be very, very difficult, the better way to solve these problems is, rather than trying to go through this whole thing, is to have the co-tenants come to some sort of agreement about how they're going to split the value of the improvement, the costs of the repair, the whatever it is. Okay, because though these rules are fairly simple to say, these numbers are very difficult to prove. And since that's the case, an improving co-tenant would be wise to come to some sort of agreement about how it's going to be handled if there ends up being a partition. Questions here? Yeah, Kimberly.
What happens in a situation where, hypothetically, say 3 people invest in investment property and one of them makes a decision that costs more than the property's value? Would that person then owe out of pocket? Say like they buy a house for $30,000 to invest in. A hires someone who's unlicensed to add an extension onto the house. That person comes in, rips walls out, destroys the foundation. The house is no longer worth $30,000, and now they're at more of a loss than what they invested in it. Would A then owe $10,000 each out of pocket to B and C?
So you're saying that the property is now valueless?
Yes, like they completely destroyed it. Now there's like sewage seeping onto the property. It's going to cost more to fix than what the property's worth or something.
So I just want to be clear that until there is a partition, the answer is A doesn't owe anything. Okay. Until there is a partition, then though A has destroyed the value of the property, A cannot be sued yet, right? Now, B and C might be sufficiently ticked off to seek a partition here. And in your example, the partition is going to either deliver a 0 in partition by sale, which seems a little bit unlikely, or maybe it's worth talking about how this would work in a partition in kind. And that is to say that the improvements go to the improver where possible, but if necessary, OLT to account for the increase or decrease in value would be ordered. And so I think what you're asking, Kimberly, is answered with this idea of OLT. that if the entire value of the property is destroyed, then A could be, yes, be made to pay 10,000 or whatever they've done to the value that B and C had. If they've destroyed it entirely, then they would have to make it right. Does that make sense?
It does. Thank you.
But do keep in mind that until there is a partition, the answer to all these questions is nothing, right? Nothing happens during co-tenancy in the absence of an agreement. Anything else on this?
Yes.
Okay, go for it, Tierney.
Could you post these slides, the accounting for benefit slides?
Sure.
That's all.
Okay. All right. Well, we're at 11:16, so we're done. I will see you guys on Monday. Do those conveyance practice questions that are on the that are on Twin, and come with other conveyance questions that you have. I'm going to set aside that Monday just for that.
I do have one quick question, Professor.
Okay.
For our final grade, will it just be our final?
I think so. I have to go look. I know that there were other things that were originally incorporated in the quizzes, etc. But I don't think that there's anything other than the final that I'm evaluating. So yeah, that's normally that's how I do it normally. This semester I was, y'all know that I was toying with changing that just slightly, but that didn't work out.
Yeah, it works with me.
Okay, well, I guess we'll see. We'll see how you do on the exam.
Yeah,
So
I
don't
guess
speak so soon.
I guess that's true.
Yeah.
All right, thanks.
Okay.
I just wanted to, when we're doing the, your practice exams online, are there answers out there to check conveyances, for example?
Nope, but you can send them to me, and I will look through them, compare them, and sort of add comments. So I've been doing that for a few people as they've sent them. So that's the best way to do it.
Okay, thank you.
Mm-hmm.
I waited till the end. What's the difference? Because this doesn't really go with what we've been talking about. What's the difference between being certified to the state and escheating to the state? I've seen some stuff where, like, with delinquent taxes on property, it gets certified to the state and then they can redeem it.
Mm-hmm.
What is the difference there?
Well, I mean, I'll start with what escheating is, and what you just described is not escheating, right? Escheating is when there is no one else to inherit the property, right? So if you have property and you die and there's nowhere for it to go, which is a very, very, very rare circumstance. But if that's the case, then that is when escheating happens. There are other situations in which property might be transferred to the state, like a tax foreclosure or the types of circumstances that you're just describing. But I would separate that out as two distinct types of ways in which the state gets property. One is because you've done something wrong. The other is because there's nowhere else to give the property. Like you died without heirs and you didn't put it in your will.
Okay. All right. I
make sense?
remember that. Yeah. And I was just thinking about other ways because there was like a conveyance problem on one of or maybe it was a worksheet or one of the exams where I can't remember exactly, but there were like two ways it could go to the state. Like somebody left it to the state, and then after that, there were no heirs or anybody to get it. Yep. So I was kind of like, well, then just would it be a sheet to the state if somebody? Well, no.
Yeah, I know. I think I know the one you're talking about. And I think that one of the interests escheated to the state and the other was conveyed to the state. And so the
Okay.
state ended up holding both the present and future interest. And when that happens, the state just has a fee simple.
So do we need to make that distinction if there's a question like that on the exam, like say part of it is sheeted and part of it was conveyed and now it holds a fee simple, or can we just say the state has a fee simple now?
I think you can just say the state has a fee simple. There might be like a briefly explain, and if there is, then you probably want to talk about is cheating. But the other part of it, like when you say certification, that's not sort of within the bounds of our course, so I wouldn't worry too much about that.
Are we going to talk about that at a later time, or is that just something you learn down the road?
Yeah, just something you would encounter down the road, I think.
Okay, well, thank you.
Okay.